Losing a loved one carries a heavy emotional weight. Handling their estate in the aftermath can feel incredibly overwhelming, especially when courts get involved. The process you often hear about is called probate. Probate is simply the court-supervised process of safely transferring a person's assets to their rightful heirs. In California, this legal process generally kicks in if the deceased left behind property strictly in their own name, valued at over $184,500. There are exceptions: assets held in a living trust or financial accounts that have a direct named beneficiary bypass the probate system entirely. For city residents, this process is strictly managed by the local county court, as shown here on the official seal of the Superior Court of California, County of San Francisco. Despite the formal courthouse setting and the complex legal terminology, the entire probate system breaks down into a predictable, manageable 6-step roadmap. This roadmap outlines our journey. The core framework begins here with Step 1. The process starts by filing a petition with the San Francisco County Court. As of July 2024, these petitions must be submitted electronically through their e-filing system. Moving to Step 2, the court officially appoints the estate's representative. If a valid will names a manager, they are appointed executor. Without a will, the court assigns an administrator to the role. Regardless of title, the representative becomes a fiduciary, legally bound to act in the estate's best interest. Moving to Step 3, they send official notices to surviving family and potential creditors, alerting them the process has begun. These first 3 steps are administrative. They ensure the court, family, and public are on official notice before any property actually changes hands. Next is Step 4, where the representative takes inventory of everything owned, from bank accounts to real estate. For non-cash assets, a court-appointed probate referee determines their exact value, establishing a clear baseline. The inventory provides data for Step 5, deciding what to do with the property. The first path is keeping it for heirs. The second is renting it for income. The third is selling it to pay debts or divide the value. Exploring this decision tree prevents rushing into a sale. It provides the necessary data to maximize and protect the estate's total value for the family. This brings us back to our timeline for Step 6, the final phase where the estate is officially distributed to the heirs. Before any heir can inherit, all approved creditor debts, final taxes, and statutory court fees must be paid out of the estate's funds. In California, the compensation for both attorneys and executors is fixed by state law, typically ranging from 0.5% to 4% based on the estate's total value. With debts settled, the representative submits a final accounting report to the court. This crucial document proves to the judge that all legal rules were followed. Once the judge approves the report, the remaining assets are legally dispersed to the heirs, bringing the probate case to a close. Step 6 is the finish line. The legal burden ends, and the family's legacy is securely established. Looking at this entire timeline, completing all 6 steps in California takes an average of 9 to 18 months. This duration is driven by mandatory legal waiting periods that give creditors time to respond to notices, combined with the natural, everyday caseload of the county courts. Instead of viewing this timeline as a delay, consider it built-in breathing room. It provides the necessary months to make major decisions about real estate and physical property without feeling rushed into a choice. Because local procedures update frequently, seek out guidance from a qualified estate attorney who understands the specific rules of the San Francisco courts. While California probate requires patience, keeping this roadmap in front of you makes the journey entirely predictable, safe, and manageable.